Recall Sam from Mail and Wire Fraud Part 1. Sam swindled customers who deposited money with his cryptocurrency exchange by transferring those deposits to his cryptocurrency trading fund and using them to trade on his own behalf. Recall that Sam moved funds via wire transfers, mailed falsified account statements to his customers, and communicated with customers via email. Mail and Wire Fraud Part 1 covered the first three elements of these crimes, namely, a scheme to defraud, intent, and materiality. The last element is the use of the mail or wires. A defendant must use the mail or wires for the purpose of executing the fraudulent scheme. This use need not be an essential component of the scheme and may even be incidental to it, but the mailing must be in furtherance of the scheme. For simplicity, we'll use the word mailing to cover use of both the mail and wires. The same rules apply to both. In Schmuck v. United States, the Supreme Court held that a mailing is in furtherance of a fraudulent scheme if, as conceived by the perpetrators, it's part of the scheme's execution. Schmuck was a used car broker. He bought used cars, rolled back their odometers, and then sold them to used car dealers at inflated prices based on the fraudulent lower mileage. The dealers, ignorant of Schmuck's odometer tampering, resold the cars at inflated prices to retail purchasers. State law required the dealers to complete title application forms and mail them to the state to obtain vehicle titles for the retail purchasers. Was this use of the mail sufficient to support mail fraud challenges against Schmuck? The court said yes. The mailings were part of the ongoing scheme's execution. Schmuck knew that to keep the fraud going, the dealers would have to mail the title application forms. If the dealers couldn't transfer title to the purchasers, the scheme would fall apart. The title applications weren't directly a part of the fraud, but they were necessary to the passage of title, which in turn was necessary to continuing the fraud.